In a state where union membership falls well below the national average, lately unions have made waves in a number of industries, from healthcare to mining and even journalism. We took a closer look at some of the issues involved. But first, employment attorney Barney Holtzman offered insight on the role of unions and workers' rights in Arizona. Remind us, right to work state, what that means here in Arizona.
So a right to work state means that the employer cannot force the employees to be members of a union to work at their place.
Okay.
So right to work really only deals with the union workforce. A lot of people confuse it with an at-will state, which Arizona is an at-will state, which means that your employment relationship can be terminated with or without cause and with or without notice.
Okay. Right now there's a conversation about unions in Arizona. There are in fact unions in Arizona, but not every industry has them, correct?
That's correct. The National Labor Relations Act is what governs unions and the unionization of workforces. It covers all private employees other than some areas of transportation and some areas in agriculture. So any industry that is not those specific ones are allowed to unionize, but it requires a vote of the membership of the employees to say we want a union to represent our interests. Instead of us having a one-on-one relationship with the employer, we want a union to represent us in terms of setting our pay, our benefits, the terms and conditions of employment.
How does the workplace change once an industry is not a union and then becomes one? I mean, is there a difference in the environment?
So it can change the environment. At that time, once a union is in place, they have to bargain with the employer. And so you have representatives, and that's what you see in the news today going on at the hospitals with the nurses, is their union is negotiating with the hospital about what the terms and conditions are going to be. What are we going to pay our employees? How many breaks are they going to get? How many vacation days will they get? And then the relationship is managed through that contract that is created. It's called a collective bargaining agreement, as well as through the system that is created in that. So oftentimes, instead of things being determined by the employer specifically how they're going to deal with the situation, they look to what the contract says. And the contract says, for this violation, for example, here is the punishment that will happen to the employee.
Among the terms we've heard in this conversation are an employer has to provide basics in the workplace. What constitutes basics in the workplace?
So there are very little in Arizona. A lot of it is based on state law in terms of what are the basics. For example, one thing that I know a lot of people are always surprised by is that employers do not have to give you a break. In Arizona, there's no requirement of a mid-morning break. There's no requirement of a lunch break or anything like that. And so the real requirements are that you have to pay the minimum wage and you have to pay overtime if the employee doesn't qualify for an exemption from the overtime requirements. You have to provide a safe working environment. Yeah. And that's pretty much, I think, the minimum requirements in Arizona.
Sometimes employers have been known to say things, if you don't want to do this work, I can find someone who will, or if the pay is not appropriate for you, there's someone else out there chomping at the bit. That may not be tactful, but it is done. Is it legal?
It is not tactful and it's not good for morale, but it is generally legal as long as what the person is complaining about is their pay or some conditions of employment. And if it's just them individually saying, I don't like my pay, that's where we get to that at-will work state. And you're an at-will employee. If you don't like that, then you can quit, or if you come back to work, then you're under that. Now, if you bond together with your coworkers and you come to your employer together, and the three of us, for example, three people come and say, we don't like the way you're doing this. And you say, as an employer, well, I'm sorry, leave. You may have very well violated the National Labor Relations Act, which says you as an employee can bind together with your coworkers and come and complain about the terms and conditions of employment. And that's called what we call concerted activity. They're working together to complain about terms and conditions of employment, and they're protected by the National Labor Relations Act, even though they haven't formed an official union. In a sense, that's their own little union, so to speak.